now let's start our second keynote session, that is intellectual property challenges of blockchain and artificial intelligence in the post COVID-19 period. And we have our keynote speaker, Professor Dr. Tabrez Ahmad, Vice-Chancellor and Dean, School of Law, GD Goenka University, and founder Technology. So a very warm welcome, Mr. Tabrez, and thank you so
Thank
much
you.
for joining us today.
Welcome.
Yeah, thank you.
So, welcome you all in the keynote session on intellectual property challenges of blockchain and artificial intelligence in the post-COVID-19 period. You know that blockchain and AI are the buzzwords of late. The former quickly rose to the limelight with the Bitcoin saga, and the latter is finding its way into people's life as we speak, be it through smartphone, cameras, or while browsing the internet. Simply speaking, blockchain is an indestructible ledger associated with an asset that builds over time and remains with the asset. This opens a variety of applications tracking the ownership, checking for any sale and transaction of the asset, tracking whether an asset was illegally sold, or with so many industries experimenting with the blockchain technology to make it work for them. Patent industry is no different. Some notably early starters who seem to have started service offerings in this area are an Estonian company, Agrillo, is trying to implement blockchain in creating smarter contracts. Another company, Binded, is trying to leverage blockchain to serve as a proof of the copyright. Another player, Bernstein, is trying to leverage blockchain for management of IPR, such as patents and other areas. In addition to blockchain, the other upcoming technology is the artificial intelligence is also quickly percolating in the field of IPR, especially patents. Some early adopters were the companies that provide searchable databases for patents across the globe. For example, an Australian player, Amberside, uses AI engine to search for patents that allegedly throws little or no noise, making the overall process of searching and analyzing the patents very efficient. Not only the commercial players, the patent offices across the globe are also leveraging the technologies to unlock potential benefits. For example, the US Patent Office implemented AI engine to suggest patent classes that should be searched to make the process more efficient. The Indian Patent Office seems to be no exception. There was a tender announced by the IPO, expression of the interest for making use of artificial intelligence, blockchain, IoT, and other latest technologies in the patent processing system of the IPO. In this tender, the IPO has expressed interest in leveraging the technologies including blockchain, AI, and IoT to make the patent process smoother. When the envisioned system is ready, it will enable a blockchain AI-based ecosystem for managing IP protection in India, which will be much more efficient, smooth, and faster. But this is all but a beginning, and the road to be traveled is very long. The fundamental principle of AI-powered system is one in which a trained set and an expected output set is provided to every AI engine for it to calibrate itself. Thereafter, the AI-based engine can thus operate on another data set in real time to produce the same desired output. All this sounds good for highly structured data, but the patents are very unique. They are techno-legal documents that can be very diverse, even though they relate to same technical domain. The question is, would we need to have an AI-backed engine for every class of technology? If yes, what is the level at which we need to define technology? Is automobile a suitable level technology for AI, or one needs an AI engine for each component of an automobile, such as engine etc.? Also, with fast-moving technologies such as electronics and computer science, the terminology included in patents also changes very quickly. How frequently such AI engines needs to be recalibrated? All in all, we can safely say that both AI and blockchain are in very early stages. And though not without potential, it will be some time before we see the full extent of the benefits it can extend to the patent sector. Uh, IPR, information technology and IT-enabled services have become significant contributor to the global GDP. As we live in an era of innovation and interconnected world, IPR and IT spans the life of humans and corporations alike. In order to emerge as a superpower of tomorrow, we need to create and protect IPR. AI can play a big role in defining the future course of action, and COVID-19 has proved the power of digital and the internet technology very efficiently. The growth of AI across range of technical fields raises a number of policy questions with respect to IP. The main focus of those questions is whether the existing IP system needs to be modified to provide a balanced protection for machine-created works and inventions. WIPO has started an open process to lead the conversation regarding IP policy implications. In fact, last December, they have circulated the white paper, a document, and asking the suggestions from all over the world. So I request all the participants, please go through the website of the WIPO and download documents. You will get a chance to provide your own suggestions that will further provide maturity of this particular area. The AI has emerged as a general purpose technology with the widespread application through output technology and the society. It is already having and is likely to have increasing in future a significant impact on the creation, production, and distribution of the economic and cultural goods and services. As such, AI intersects with intellectual property policy at a number of different points, since one of the main aim of AI policy is to stimulate innovation and creativity in the economic and cultural system. As policymakers start to decipher the wide-ranging impacts of AI, the world the WIPO has started the engaging the aspects that AI that are specific to IP. There are several threats to this engagement, notably this AI in IP administration, IP and AI strategy clearinghouse, and IP policy. You talk about the what is the how the AI is going to create the challenges for the protection and the policy making. Especially, I see a lot of challenge with the AI, with the patents, with the copyright and data protection. The first question is that regarding the inventorship and the ownership, because generally, as per the law, only a human being will be able to invent and hold any patents or copyrights. But because we are seeing a lot of involvement of the AI is now involved in creating a lot of innovative works. Now the question is that how to find out that who is inventor and who is the having the ownership. We have seen Sophia currently that has got the citizenship in Saudi Arabia, and also it has got the seven other the robots as a family of robots. And even Sophia recently participated in a kind of election, and she was able to even decide the background and select the best candidate for election. It means that day by day the robots and the AI are going to become very intelligent. That's why we cannot go on denying the protection of the IP to the AI. So in that case, now we have to debate and find out, can we really change this status? And we say now even that any AI can also hold an IP. So ownership and inventorship is a big challenge right now because if you see a lot of law, even the USA is very clear that only a human being will be able to hold the ownership of the IP, patent or copyright. Same way in Indian law also says that to hold an IP, you must be a human being. So now the question is that how long we are going to deny this particular kind of the rights. Second issue is that patentable subject matter and patentability guidelines. Now the point is that AI products and the blockchain products, whether these products are able to provide all the requirements to get the patentability, because it must be inventive step, there must be non-obviousness, it must have industrial application, utility, it's not going against the public policy. So there is a very challenging question to find out and satisfy all the requirements to get a patent, because the next issue is regarding the inventive step or non-obviousness is a very big challenge, because if you see the structure of the software or the AI, it is mostly based on the kind of one and zeros, electrical impulse, no electrical impulse. So its kind bits and bytes are there. So it is very good to provide the copyright protection. But if you go to provide the patent protection, satisfying the non-obviousness in a software or AI system is a very, very challenging process. Now the next point is disclosure norms. How much you are going to disclose? Because most of the companies who are going to use AI, they are not coming forward for the patents, because you know that if they will be able to maintain this secrecy and not give disclosure, and they can also enjoy the trade secrets. In that case, they can have the more kind of benefits by trade secrets. So we have to find out the parameters that we have to encourage the companies to come forward to disclose their kind of the research, because if they will not come forward, they will not be applying for patents, or we should not have very good policy for refining the patent law. In that case, future development will not happen properly. Because if law is very clear, very foolproof, and we are able to encourage people to come forward and share their research, future development will be very easy on this area. Next question is that general policy considerations for the patent system, because we have to find a kind of international law. So I'm very happy to see the WIPO has taken the lead and trying to share the white paper where everybody in the world is getting the chance to come forward and do a research and share their experiences, because this way we can really develop this law. So and again, so going forward, because now every country, sovereign country, they have further liberty to change their specific laws. So I think all the countries who are very fast growing and they have more kind of protection in the AI in this area, and I'm very happy to share that India is one of the among the top 10 countries who has filed maximum AI patents in the last 1 year. This way, India is taking the lead, and I'm very happy to share, because most of the engineers from those who are working, Indians who are working in the IT industry, they are able to do a lot of innovations and able to produce a lot of new technology and AI and blockchains. Now the next issues
Dr.
are coming
Tabrez?
in the area of the copyright, that authorship and ownership. Same way in the copyright area, generally the person who is able to create something or able to provide the new expression of the thought and process, he is able to
Dr.
get the
Tabrez?
copyright. Now same thing,
So,
because in the area of the AI, somewhere if you're going to get the copyrights, chimpanzee case in USA, a few years back, where the very famous photographer, he went to a kind of forest and he was clicking the photographs. One chimpanzee came and picked up the camera and went to the highest point of the peak of the plant, of the tree, and clicked very great photos by the camera, and also clicked a lot of selfies. These photos were very great photo, because you cannot, a person cannot go to the highest peak and click the photographs to a forest. And that particular famous photographer wanted to claim the copyrights, but the one of the NGO challenged this particular point and said that how that photographer is able to get the copyright, because the photos were clicked by the chimpanzee. In that case, chimpanzee should hold the copyright. So already, and then we have seen in the American Supreme Court has debated this issue, and also we have seen a lot of cases are coming. And in that case, we have to find out very good process, because the future is dependent on the blockchain and AI. That's why we have to refine this law at the global level, at WIPO level, and also find out something at international law. So all the member countries at WTO level will be able to have this law as a kind of the model law, and then they can change that law keeping in mind the country specific status to provide the growth and development of the AI and blockchain. Because if you see the kind of benefits, the kind of time saving and the cost effectiveness of this area is very important for future development. Next is infringement and exceptions. Now, if there is some infringement by the AI, the question will come that how we are going to punish the AI and how we are going to fix the charges. Same way exceptions, because in copyright area there are a lot of exceptions for the fair use. So how we will ensure that the AI, if it is using any kind of creations and expressions, will be able to filter out and do only those who are fair use, because fair use is given for development to a human being. Now we are talking about an artificial intelligence, whether we are able to have same subject of description or not. Next issue is regarding the deep fakes. We have a lot of technology that is providing the kind of fake voice and fake photographs and reducing your age, face expressions, and mixing and providing new creations. So also we have to find out as a policy matter whether deep fake should be allowed or not. So ultimately, it is going to create a lot of general policy issues, and also the database protection and AI is a very big area to explore with these words because of save time and close here. And thank you, the IPR Gorilla, for giving me the chance to provide the keynote address. And also thank all of you for patiently listening my keynote. Now the